Hey there, Paul Rabelais again. Happy to bring you another video on our estate planning site. This one comes up a lot, and it can be a little bit controversial at times, it seems. It's when people put their legal affairs in order, they often have a decision to make, and that decision typically revolves around, do they use a will as the legal instrument to leave their estate to their heirs, or should they use a living trust, or commonly referred to as a revocable living trust, as the legal instrument to pass along their estate to their heirs. So let's look at the basics. Then at the end, I'm going to share with you comments that people tell me when they make that decision and why they wind up making that decision. So first, let's talk about the will, then we'll talk about the trust. This is the basics. If you have a will, you'll have a will that may say something like, in part, it might say, I leave my estate or certain parts of my estate to my spouse. Might say I leave my estate or certain parts of my estate to my kids. Might say I leave my estate to a testamentary trust. Some people get confused about this. So some wills and will plans say I leave my estate or part of it to a testamentary trust that will go into effect when I pass away, when my will takes effect. So that's different than a living trust, because some people have a will and their will says, when I die, I leave assets to my minor children, my irresponsible heirs, to my spouse, and then back to my kids when my spouse dies. So, but some wills, many wills have provisions where they leave things to a testamentary trust, called that because the terms of the trust are part of the last will and testament, and so, but very different than, as you'll see, from the trust that we'll get into in a minute. And then some people, for the Louisiana folks, might have wills that say I leave the usufruct of my estate or part of it to my spouse, and then when my spouse dies, assets go back to my children, the naked heirs. Doesn't have to be spouse and children, but that's common. And so when you have that, we call it the will plan, you leave all of your assets in your name. You don't retitle anything. And the assets that you leave in your name are your home, your other real estate, your investments, and so forth. Probably worth mentioning at this point in the video that you may also have some assets like IRAs, retirement accounts, maybe annuities, maybe life insurance. Those pass to designated beneficiaries. The will has nothing to do with where those assets go because they go to the designated beneficiaries. So nonetheless, you leave all of your assets in your name, and then when you die, your assets are frozen. Even though you had a will, and your survivors, the executor that's named in your will, the heirs that are named in your will, they will hire an attorney or attorneys because a court-supervised process is necessary. A lot of people call that process a probate. In Louisiana, we often call it a succession. But they'll hire attorneys to take the family through that court process, because it's our courts. It's been determined many years ago that our court system is responsible for overseeing the management, the administration, and ultimately the disbursement of assets that are in your name when you pass away. So some people perceive that as being a hassle, being expensive, hiring lawyers, and so some people go the revocable living trust, I'll call it living trust route. So here's that example. You set up your living trust, and perhaps your trust says, when I die, I want assets from my trust dispersed to my spouse, or perhaps dispersed to my kids, or perhaps your trust will say my trust will continue after I die, so that it will go on for irresponsible heirs or minor children or minor grandchildren, or assets will remain in trust for your spouse, and then when your spouse dies, the remaining assets go back to your kids. So similar type provisions, but they're in your trust instead of your will. And then the difference between the two is you don't leave your assets in your name. As part of getting your trust set up, there's a retitling of assets that's necessary, so that when you die, the assets are titled in the name of your trust. And again, those assets typically include your home, your other real estate, your investments, and so forth. And when you die, the trust assets aren't frozen. Attorneys in the court system don't have to get involved in the settlement of a trust. The court system is there to oversee assets that are in your name when you pass away, so trust assets don't have to go through that process. In your trust, you designated what's called a successor trustee or successor co-trustees. Maybe that's your spouse, maybe it's an adult child, maybe it's more than one adult child who will have the immediate authority to go ahead and disperse assets out of your trust to the beneficiaries that were designated in your trust. Now, which should you choose? Well, it's ultimately your decision, but the following is what our clients have told me when they make that decision, and so let me go through some of the will comments we hear and then the trust comments. Some of the will comments that we hear clients tell us when they've made that decision, they often base these decisions on their personal prior experiences. So some of our clients will tell me, you know what, Paul, my mother died 12 years ago. I don't remember her probate being real difficult. Sure, we had to go through the probate because she owned a home when she died, but you know, we weren't in any big hurry, and I don't, I don't see that it's necessary because of what happened when my mother died 12 years ago with her home that we set up a trust. Let's just do the will. So that's one set of comments we hear. Another set of comments we hear are maybe something like, Paul, I don't have any children, so if my favorite charities and my distant relatives that I've named in my will have to go through a court process to get what I have, so be it. I want it to be as easy as possible on me while I'm alive, so I'm going to leave everything in my name. Let's just do the will plan. Now, trust clients will often say something different to me based on typically their prior life experiences. So when people choose a trust, sometimes I hear, Paul, when my father died, his probate seemed like forever, and it was difficult and it was expensive, and I don't want my kids to have to go through what me and my siblings went through when my father died. Let's set up a living trust. Or I might hear, Paul, my spouse and I want to make things as easy as we can on each other when one of us passes away. So if we can avoid just that, attorney and court involvement, let's do that. Might hear, Paul, if my spouse and I can set up a trust now and get things titled in a way so that the two probates are eliminated, it sure does seem like a no-brainer to have a trust and avoid the necessity of two probates, one when each one of us passes away. Other people, just based on their own experiences, might say something like, we pre-arranged our funeral expenses because we're trying to get all our affairs in order, and we want to do as much as we can to pre-arrange things. And what we did with our funeral arrangements, we'd like to do that with our estate. Let's set up a living trust. And then some people, incorrectly or correctly, might tell me, Paul, I want to set up a trust because I want to take the assets out of my name, put them in a trust so that I don't have to consume all of those assets if I go into a nursing home. Now that requires a different discussion because the typical avoid probate revocable living trust doesn't protect assets from the nursing home. We got to talk about a different kind of trust with different provisions for that, so that's a separate discussion, but we hear that a lot. Now, if you go the trust route, it's really important that you watch my popular video on YouTube titled, If You Have a Revocable Living Trust, Watch This Now. Just search for that. It'll pop right up, and that discusses the importance of having assets titled correctly if you have a trust. So that's a real critical component of making sure the trust plan just eliminates all that probate necessity. So bottom line on this is make sure you take action and talk to an estate attorney. Hopefully, when you do talk to an estate attorney, they won't be so biased one way or another to prevent you from being able to make, truly an informed decision as to what you feel is right for your family. But it is critical that you take action. Some clients, because it's an end-of-life discussion, and some people perceive it as being uncomfortable, although it doesn't have to be uncomfortable, but they perceive it as an uncomfortable, conversation. Some people, are guilty a little of that, either procrastination or paralysis by analysis. So really important that you take action, have the discussion, work with the right people, put things in order, get the peace of mind, leave a legacy, so that just this component of getting all your legal affairs in order, you don't have to worry about anymore, and it's all taken care of. So hope that helps. Make sure you go out and leave a legacy, and have a great day.